All right, so what I'm going to go through this morning is a real cook's tour of where we are with fines at the moment and how all the infringements acts, the reform acts and the current bill all fits together, just to get us started and thinking about where we are and what's going to be happening in the next 6 to 12 months in the fine space. Everything that I'm going through now is in your materials, so feel free to refer back to it. And if there's any particular things, I'll try and remember to point out where they are in the materials. Alrighty, so here we are. Like any good play, we are currently dealing with 3 acts. Our Infringements Act, our Fines Reform Act, very ungainly named Fines Reform and Infringements Act Amendment Act. And then at the end of the play, we have the bill. That will hopefully bring it all together and fix a whole lot of the problems that the first 3 acts introduced. To start, we still have, past fines reform, we still have the infringement notice coming first. The thing that we need to be wary of here is that we'll have shortened time frames, and that's something to be wary of throughout this entire process, as you'll hear me say quite a lot. There'll be less time. Same process, less time. Same as before, issued by the infringements agency, specifies a monetary payment, pay it, and it expiates. Failure to pay, penalty reminder notices will still be the same, but again, reduced timeframes, so down to 14 days from 28. Very much similar options available as well. So options for infringement notice and penalty reminder notices are still, will still have pay the fine, and any additional costs, which will be indexed as before. Nominate the other person for the driving fines, and applying for internal review. Some key changes there to be aware of is the inclusion of family violence as a special circumstance, but that still requires the nexus test, as it does currently under special circumstances. We've also got person unaware, that was added as 1st of July. One good thing that has already commenced is the automatic referral to court. So if you do make a special circumstances application now for internal review, the enforcement agency does not have to refer it to court if it says no. So that should give you the opportunity to try and head your client's matter off before it gets into the infringements court or into Fines Victoria or after Fines Reform commences, in an effort to try and reduce that burden. Very useful if your client only has a small number of fines, and a much safer option for the client because you can actually get 2 shots at the review. So you can do the internal review and then a further enforcement review afterwards if the first review is rejected. The person unaware provision has been in place since the 1st of July. It says some severe limitations on when it can be used, and it doesn't generally get to the underlying offence. One further change that we all need to be aware of is the introduction of the oversight guidelines that have been in place since the 1st of July, which provide for independent oversight of those internal reviews. Will be with the Director of Fines Victoria. One of the key pieces of guidance in those guidelines is around the definition of exceptional circumstances, which we will talk about later, and is in your materials, the full summary of what the guidelines talk about as exceptional circumstances. And I'd encourage you, if you are doing internal reviews, to refer to those guidelines. It is something that we hope will improve the quality and consistency of what, in particular, local councils are doing when they are doing internal reviews. We still have payment plans, which I'm sure you're all aware of, defined as not necessarily a payment plan, but can just mean an extension of time. That definition hasn't changed. So payment arrangements, as opposed to payment plans, will be managed by Fines Victoria, and the intention there is to give a single payment arrangement for all fines. So that could be fines that are court fines, for infringements, for things that have progressed to the notice of final demand stage, and also has the capacity to call in fines from external enforcement agencies. So hopefully we'll be able to utilise those to great effect to prevent our clients' matters from escalating. Another option available now is the work and development permit, which we will hear a lot about in the second panel, so I won't go into that in great detail now. but there are some key contacts in your materials about who you can contact if you think you have a client that could be eligible for a work and development permit. The key to note here is that a lot of the criteria are the same criteria as for special circumstances, but you don't have to prove the nexus. So that idea of mental illness, intellectual disability, disordered disease, addiction, you just have to connect it with the offending. So it will expand the availability of an option for people who would otherwise not have one. Also provides for, also eligible if you have acute financial hardship, which at this stage is defined, now correct me if I'm wrong, Maria, I believe it's defined as if you're on a healthcare card or low income. It will satisfy it. So the work and development permits provide an option for people to work off their fines through whether it be casework, financial counselling, drug and alcohol counselling, volunteer work, or education. So it can be a really useful tool for some people. At the moment, they are hard to obtain because of the lack of sponsors, but we hope that over the next couple of years that sponsorship will grow and will be a very common option for a lot of our clients who would otherwise be stuck on payment plans that they can't afford to pay. The final new option is the family violence scheme, which is currently part of the final bill that you will have seen was introduced a few months ago. Essentially, the family violence scheme will allow people who were not the driver to have a simple and clear scheme that they can utilise to try and address the fines incurred by their violent partner. You can see there the two criteria that will allow somebody to access this scheme. It will allow people to expiate their fines or have their fines removed without nominating where it's unsafe to do so, which is a huge win and huge benefit to our clients. And the option to go to court still remains. So if your client objects under Section 16 of the Infringements Act, they can still apply and have it referred to the Magistrates Court at that early stage with the same options available as under the Sentencing Act. And then delay, take no action. Previously, that was occasionally good advice for people. If they had lots of fines with different enforcement agencies, it was better to get it sent through and all collated at the Infringements Court, especially for special circumstances clients. Now that the enforcement agencies don't have to refer on a rejection, it may be more sensible now to make those special circumstances applications earlier, and especially once payment arrangements are available, if the advice is that the person is eligible and should apply for a payment plan, applying for that as early as possible during the payment arrangements will also be an improvement over delaying, as it will keep the costs down. So then we move into the middle of the process, issued by the Fines Victoria, called a Notice of Final Demand. The big change here is that a lot of the enforcement powers that were reserved for the sheriff have been pulled forward, and they're in this administrative stage, with the addition of a couple of new powers, such as the removal of number plates. So what we shall see here, as I've alluded to at the start, is more enforcement happening earlier. Also got the current guidelines around attachment of earnings and attachment of debt, and we're hoping that those are not used as much as the guidelines seem to be pushing them towards, because at the moment the guidelines for attachment of earnings is when the earnings are above 75% of new start. So we could find people with incredibly low income being subject to attachment of debts or attachment of earnings. So that's something that we'll need to be careful about in the future, as if those sanctions are applied, their other remedies are actually removed. So we need to make sure that if our clients are receiving those notices that an attachment of debt or attachment of earnings is proposed, that we're acting on those very quickly, and that our clients are aware of the timeframes there, because we were going to have to move very fast. We also have a warrant as before, although that will be called an enforcement warrant instead of an infringement warrant. At the moment, you'll be receiving the notice of intention to issue a warrant. That will be removed, and it will simply go from notice of final demand to warrant. Similar powers to before, where arrest, seizure, sale of assets, things like that, but a lot of those previous powers, such as attachment of earnings and things like that, as I said, are moved earlier in the system. Revocation, which will be known as enforcement review, with the same options as are available at internal review, with family violence as included, but with that nexus test that you have to prove that it results in. Under the enforcement review system, you will only be able to make one application for enforcement review, or two applications if they're for special circumstances. And after that, the only option is to object through judicial review. Although a question that has just occurred to me then is, because it will become an administrative function, it may actually then fall within the jurisdiction of the Ombudsman. So maybe an option for us to look at. Another change is around when the sanctions can be applied. So with enforcement review, you'll be able to stop further sanctions, but any current sanctions that are applied will remain. So it is important that if our clients are receiving notices that their licences are going to be suspended or something like that, that we are getting an enforcement review application in as soon as possible to try and stop that sanction being applied. Once the sanction's applied, it's stuck there until the review's determined. Work and development permits are available at this stage of the process as well, thanks to some changes that went through in the Fines Reform Amendment, Infringement Amendment, Act Amendment, or whichever second one it was. And then we've got the family violence scheme that will be introduced hopefully early next year, with the same process available at the notice of final demand stage as is available at the infringement stage. And then we get up to the pointy end. So 7-day notices, and this is something where we all need to be very careful, because currently a 7-day notice doesn't mean a whole lot. It allows the sheriff to execute some powers, but chances are the sheriff will issue the 7-day notice, but you'll still have a bit of time. Under fines reform, once the sheriff's notice, the 7-day notice expires, no other options are available, and you just have to wait for that warrant to be executed, which is a terrible position for our clients to be in. So we need to make sure that if clients are coming to us with notices of final demand, that they're aware of what 7-day notices are, and that if we're waiting for materials, that we can do our best to make sure that the client tells us if they get one of those 7-day notices, because we only then have 7 days to put in the applications, or else they'll have no options and they'll just have to wait for execution of the warrant. As I said, execution of the warrant, similar powers as to now. Some of those sheriff's powers have now been pulled earlier and will be administrative. And seize and sell assets, no significant changes there. And then we still have our penalty enforcement hearings. So at the moment we're looking at Section 160 of the Infringements Act, which will be Section 165 of the Fines Reform Act after fines reform. We've already seen some partial harmonisation of the powers between what the court can do at Section 160 and what the court can do under the Sentencing Act. It's also introduced some changes to make imprisonment an option of last resort, to make sure that if a person does have special circumstances, that they can also now discharge those fines in full. At the moment it's partial harmonisation, because the infringements can be discharged in full, but now Sentencing Act fines are still only up to 2/3. That is in the current bill to harmonise that section.
Now, a number of changes were made to Section 160 of the Infringements Act on 1 July. So these amendments included making imprisonment in default of payment an order of last resort. It also widened the eligibility criteria for full or partial discharge, and it also removed the 2/3 restriction for partial discharge. So in our experience, the infringement warrant cases often would be of a large amount, so that 2/3 restriction was quite troublesome. So removing that has certainly changed the landscape for those type of hearings.
One thing to be aware of with this is with the court fines and the capacity for them to deal with excess fines and calling in, which we'll talk about a bit more later. But the last thing I wanted to point out, and the reason I went back to this slide, is we can now order instalments without IILs, or the imprisonment in lieu orders. So in the materials, there's a significant amount of time dedicated to what submissions you can make. And it's important that when we do have clients in those Section 160 hearings and later the Section 165 hearings, that we are making submissions about whether or not an IIL is appropriate, because the courts no longer have to impose them. And it should be the practice that they don't. They are in fact discouraged from imposing them under the Act. So we should be making submissions to that effect to try and reduce that practice. The less IILs we get out there, the better. We've also had a change to the disproportionate, excessive and unduly harsh. From July 1, it became disproportionate, excessive or unduly harsh rather than and unduly harsh. So that's that final element of the Section 160 test that you would all be aware of. So now you only have to prove one element of that rather than all three, which can improve the capacity of our clients to meet that test, as it is a rather difficult test to meet. It's also no longer linked to the special circumstances limb, so proving any limb on its own is sufficient. And again, in the materials, there are examples of what each of these limbs could mean and what you could present to the court to prove that an imposition of a prison term would be disproportionate, excessive, or unduly harsh. And finally, we have changes to calling in. So from 1 July, under the interim sheriff's program, which is in your appendix, the calling in was expanded to include time served from entering custody. So that will now include time spent on remand. But one thing to be aware of is it still will only apply if the person is sentenced. If the person leaves remand, is found not guilty, matters withdrawn, their time spent on remand doesn't count. Magistrates now also have a capacity to deal with excess infringements if they're satisfied of essentially special circumstances, same test as Section 160 and later 165. But you need to be careful about dealing with excess court fines. So while there is capacity to deal with excess infringement fines, if there are excess court fines, those will be dealt with cumulatively rather than concurrently. So they'll be added on to the sentence rather than being able to serve concurrently with their current sentence if they're in excess of what the period of time they're currently sentenced to. So what we'll need to be careful about is we can make submissions about what order the court should prioritise assigning the fines, but there's no guidance as to whether or not the court will do that, and it is essentially up to the judicial officer whether they assign the court fines first and then deal with the infringement fines through these new powers to deal with excess infringements, or whether they do it the other way around and cause our clients to have an additional period of imprisonment ordered. So that is an area to be careful of and something to watch and something to make submissions about if you are in that position. One of the last changes is at the moment under the sheriff's program, it only covers infringement warrants. Under the new fines reform program, it will cover all registered infringements. So once they've been passed on to Fines Victoria, they'll be able to be called in rather than having to wait for them to become warrants, which should actually reduce the period of time people have to spend in prison to meet these fines because the amounts will be lower. So that is a Cook's tour of where we are with fines reform and the Amendment Act and the current amendment bill. So in the current guidelines, the level of income allowed, the minimum level of income for garnishing is now 75% of New Start, or under the proposed guidelines. So we expect that that will be used. It's something that we have made some submissions on and something that we can certainly put to the panel in the afternoon, but it is a concern and it is projected to be introduced in Victoria. So under the proposed scheme, the demerit points will not apply to the applicant where they've been accepted into the scheme. Because what we're dealing with is severely truncated timeframes, I think it's 168 days currently down to 77 days under fines reform. So what I would be recommending is putting in that application, because the worst case scenario is it gets refused, which is still better than no application being put in at all, and asking to provide that material later, as I know that we do now occasionally. It's 6 of one, half a dozen of the other, really. Either you put in a bad application and it gets rejected and the person gets their 7-day notice executed, or you do nothing and the person gets their 7-day notice executed. So once the 7-day notice has expired, so the 7 days have lapsed, if nothing's been done in that time, none of those options will be available anymore. And you just have to wait, or your client just has to wait for the sheriff to execute the warrant. The variation and rehearing powers will be retained under fines reform, and they, under the, there's some material actually in the materials around when a variation and when a rehearing is appropriate that will answer that question in more detail. But the short answer is yes, they are retained, and where those arrest warrants are issued, they grant the court the power to essentially rehear it from the start, which is a huge improvement over sending them straight to prison. Yeah, so this is an ongoing issue and something that I think needs to be subject to some judicial interpretation. And in the future, when we are looking at judicial review as an option for dealing with adverse decisions by the Fines Victoria, we can have a look at whether or not they are applying the definition of mental illness appropriately, because gambling has been in the DSM for some time and is not being accepted as a special circumstance. And it's not been something that we've been able to deal with in the past, because in the end we've been getting appropriate outcomes through the courts. Under the new scheme, where we can't refer it into court, but we do have the option of judicial review through the Supreme Court, that may be something that we will be looking at in the next 12 to 18 months once the scheme starts. My concern is whether or not we are getting appropriate decisions, and it's why I think that getting actual judicial review through the Supreme Court is almost inevitable, because there are a lot of changes, there are a lot of penalties, administrative penalties that can be imposed if that enforcement review is refused. So I think it's likely that we will end up having to go to the Supreme Court and get some guidance on what the definition is and how to apply it, how to apply exceptional circumstances in particular, as well as that question around gambling as a special circumstance. So I think the biggest risk is that inability to object and refer it to court. But in the long run, if we do get some good decisions through the Supreme Court, it could end up being a more effective system. And at the moment, if you do object and you end up at who knows what magistrate's court, it's an absolute crapshoot as to whether or not you're going to get a good outcome or not, depending on which magistrate you end up in front of. So I think that consistency may be, in the end, better than what we have now.